Okay, please tell us your name and roll number for this exam.
Sir, my name is Arya, Aishwarya-Aarohan, and my roll number is 300-172.
Okay, so tell me, without mentioning your name, give a brief introduction.
Yes, sir. Sir, I have completed my LLM from Mazza Law College in 2020. And before that, I completed my BA LLB integrated 5 years honors from Mazza Law College from 2013 to 2018. And before that, I did my +2 intermediate course by taking science stream from Rajdhani Junior Science College. And before that, I completed my matriculation from Uniton Government High School.
You have not completed your post-graduation in law?
Yes, sir. LLM.
LLM from?
From Mazza Law College.
Okay. So, your hobbies that you have mentioned in CIA?
Singing song.
Singing song.
Yes,
okay.
Sir.
And any achievements, special achievements that you want to mention?
No, sir.
Achievements ki ishto nahi.
No.
Standard 7th or 8? Any prizes, etc. You won, moot court,
Not academics, sir, but
no, academics no. Extracurricular, co-curricular, the whole teacher.
In modeling, I have in Rochbury Award. I have.
So co standard rate.
Sir, said 2018 nitla.
Means during your graduation?
No, sir. Ko college mein nuhe, but bahare Jaydev Bihare hotla. Sethi Jaydev Bhavan ne hotla. Sethi competition mein participate karle and sethi ko winner thili.
Okay, so that you can mention, no? So that is an open competition, right?
Yes, sir. Yes,
anyone can come and join,
yes,
no? So that you can mention that the winner of this particular competition.
Yes, sir. I have also certificate of it.
Certificate se mane kichi darkar tankara nahi.
Okay.
Your skills ta apno jaha gain karchanti. They will ask you questions on that.
Yes,
so you can mention that. Blood donation keve karna thi? Okay. That you can mention that. Okay. Okay. So give us some good reasons why you are interested in joining judicial services.
Sir, in my opinion, life is all about sacrifices, and service to mankind is service to God. And in this profession gives me the opportunity to serve the people by rendering justice. And justice is also another form of God. So this is the only profession where I can get the opportunity to serve the people and to give a little bit contribution by delivering justice to the people. So in that way, I will. I think I would make my life. I would lead a successful life by contributing for the betterment of the society. So this is it.
Okay. About the feedback.
Yes, sir.
Data that you can keep it down. Solid oxygen data. So number 1, in opinion-based questions, answer in point-wise manner. Okay, opinion-based questions, answer in point-wise manner or enumerate the answer. Okay, enumerate the answer mane kona? A case. So my first reason for my interest in judicial service is this, and second reason is this. So first reason, second reason, third reason, the reason of simply consider. So simply olga bhi kichu opinion based questions is the what do you think about this, or what is your opinion on this? So you can point wise you can present your answer. Okay, so that basically organized marks okay, so that is one. Okay, so now coming to some basic questions on law, on procedural law, CPC. Is there any provision in CPC where the civil court can order the arrest of the defendant before the judgment?
Yes, sir. Under section 58 of Code of Civil Procedure 1908.
Okay. On which order?
Order order 20 order 38.
Yes, order 38. That is correct. Okay, so what is the difference between res sub judice and res judicata?
Yes. Sir, res sub judice has been defined under Section 10 of Code of Civil Procedure 1908, and res judicata has been defined under Section 11 of Code of Civil Procedure 1908. Sir, res judicata, in res judicata, res mean matter, and judicata mean have already finally decided. And in res sub judice, res mean matter or thing, and judicata mean under judicial determination. Means in res sub judice, the matter is pending for adjudication. But in res judicata, the matter has already been decided by the court of competent jurisdiction. And another point is, res sub judice is not applicable to the execution proceeding, but res judicata is also applicable to the execution proceeding. It has been defined under under explanation number 7 of Code of Civil Procedure, Section 11 of Code of Civil Procedure.
Okay. What are the conditions in which a foreign judgment cannot be executed in India?
Cannot be executed in India. It has been defined on this provisions has been given under Section 13 of Code of Civil Procedure, and as much six rounds has been provided. When the foreign judgment has violated any principles of natural justice, this is the first point. And second point is when it is contrary to any law of India. And third one is when it is not decided the material questions between the parties. And fourth one is sorry, sir. Now I am unable to recall. I will prepare for it.
Okay, that's fine. So, what do you mean by interlocutory order, and when does the court give such order?
Interlocutory order means interim order, means temporary order. It is defined. It is under Order 39 deals from Rule 1, rules 1 to Rule 5 provides the temporary injunctions, and then Order 39 Rule 6 to Rule 6 onwards gives the interlocutory orders. And for giving interlocutory order, three grounds must be there. First is prima facie case. Second one is balance of convenience, and third one is irreparable injury to the party. Yes, sir.
Okay. So, under Code of Civil Procedure, suppose a civil court does not have territorial jurisdiction.
Yes.
It has given a decree. Will that decree be a nullity because of lack of territorial jurisdiction?
Yes.
It will be nullity. Okay. Same thing for pecuniary jurisdiction also. If it does not have pecuniary jurisdiction,
Yes, sir.
decree will be nullity.
Yes, sir.
Okay. এটা লিখে দিও তো, ঠিক আছে তো, just write it down and just check it.
Okay.
Okay. Lack of jurisdiction in pecuniary, territorial, and subject matter cases.
Mm-hmm.
Will the decree be a nullity? Co case nullity hobo.
Yes, sir.
Okay. So now let us go to law of evidence. So what is the evidentiary value of hearsay evidence and what are its exceptions to hearsay evidence?
Sir, Section 59 of Indian Evidence Act 1872 states that hearsay evidence is no evidence and evidence must be direct. But Section 32, Clause 1, which states about the dying declaration, it is an exception to it. And Section 6, which states about res judicata, that means things done, including words spoken, is also an exception to it.
Okay. So suppose a witness has turned hostile.
Yes, sir.
So whatever evidence the witness has given, will that be thrown out or some part can be used? Some part of the evidence can be used.
Sir, if a witness is hostile, then under Section 154 of Indian Evidence Act, the party who calls the witness can take the permission of the court and can ask him the questions which is lawful to be asked during the cross-examination. In that case, the evidences which that witness gives is taken as a material evidence, as a valid evidence, sir. Though he is hostile, but his evidence is relevant.
Evidence
Is
is
admissible. Yes, sir.
okay. Fine. So under CRPC, is there any provision which allows a common man, private citizen, to arrest an offender?
Yes, sir.
What is it?
Under Section 173, when a warrant is issued and by a competent magistrate, and then it is to be executed by a private person under Section 73. CRPC.
So under the Evidence Act, can you tell me what is the concept of res gestae? Res gestae.
Res gestae, yes, sir. Sir, res gestae has not been defined under anywhere in Indian Evidence Act 1872, but Section 6 of Indian Evidence Act 1872 states about the principles of res gestae. Sir, it states that the fact which though not in issue but are so connected with the fact in issue or relevant fact has to form part of the same transaction, whether it is at the same time or place or a different time or place. So so here the fact means anything spoken or anything done or spoken by a person is relevant under Section 6. This is called res gestae. And it is also an exception to the hearsay evidence is no evidence.
Okay. What are its exceptions? As you said,
Res gestae is exception.
exceptions to res gestae. Not exactly exceptions to res gestae, hearsay evidence.
Yes, sir. Hearsay evidence is no evidence. It is defined under section. It is given under Section 59 of Indian Evidence Act, and the res gestae is the exception of Section 59. Sir, hearsay evidence is no evidence. Res gestae is the exception of it.
Dying declaration?
Yes, sir. Dying declaration also an exception to it.
Any other exceptions?
This one, sir.
Okay. What are the exceptions to Section 300 of IPC?
Exception to Section 300 of IPC. Yes, sir. There are 5 exceptions in these 5 exceptional cases, culpable homicide is not amounting to murder. So first exception is when a death is caused by deprivation of the self-control or in a provocative stage by the provocation, then it is an exception. And second one is when a person exercises his right of private defense and without any guilty intention for lawful purpose and in good faith exercises his right of private defense exceeding the power given by the law and commit death of that person. And third one is when there is a lawful authority executing a lawful purpose and without any premeditation of mind and in good faith and for the purpose of necessity commits death of any other person. And fourth one is when there is a sudden fight and there is not a premeditation of mind and there is a death occurred. And fifth one is euthanasia, that means mercy killing, when any person who is above the 18 years of age gives consent for his death. In such 5 cases, and these are the exceptions where culpable homicide is not amounting to murder. But under section 300, the 4 provisions which have given in those cases, culpable homicide is amounting to murder.
So you mentioned about euthanasia, mercy killing.
Yes, sir.
What is the legal position of euthanasia in India now?
Sir, in India, euthanasia has not been recognized as a defense or any. In India, it is punishable.
Active and passive both, or only active?
Both.
Passive euthanasia is not allowed in India?
I think no, sir.
Okay, sir, recent last जो कौन ही थी? Okay, हमारा passive euthanasia is allowed, active euthanasia is not allowed. Okay, and the relevant cases also you can. So yesterday only Supreme Court has given a very important verdict on abortion rights in India.
Yes, sir.
What do you know about that?
Sir, before that judgment, the MTP Act, provides gives the opportunity to the only to the married woman to abort their child during the period of till 20 weeks. But after that judgment, this Honorable Supreme Court has recognized that this provision is applicable to both unmarried and married ladies, and now the period has extended, and now a man can abort her child till 24 weeks. And it also added so many categories under the MTB Act.
Okay, fine. So that will be the end of the interview. Thank you.
Thank you, sir.
So feedback hella ठीक अछि अपना flow of speech. So ठीक अछि, eye contact was also good.
Excellent.
Content ठीक अछि, अपन जो जानचंती proper बोलचंती. So everything is smile was also there. Okay, so that should be maintained. Basically serious happening, but you are not serious. So ठीक अछि sir. So most of the things are correct.
Yes, sir.
इम्प्रूवमेंट आपण कोथरे करबे जो पॉइंट्स रा कहली से ओपिनियन बेस्ड क्वेश्चन रा के पॉइंट्स रा कहबे ओके आ जदी किछि आसुनी तो स्ट्रेट कहि देबे कि आसुनी डोंट ब्लफ और गेस ओके rest things are fine so if you have to give marks you will get around 75 to 80 for this interview.
Yes, sir.
Okay.
And sir, I have not prepared well because due to the short span of time, I have to schedule it today.
So you can